A good bunch of people today. Welcome everybody to Amcham's event on the implication of the CCJ consequential orders for business in Guyana. I would like to welcome you all to this event. I'm very happy that Amcham Guyana has taken the initiative to create space and opportunity for dialogue at this level in Guyana, something that is badly needed. I would like to also recognize our three panelists. Um, I'll give Zulfikar, the president of AmCham, that opportunity. I will also like to thank you all for being here this afternoon. So without further ado, Mr. Zulfikar Ali, the president of AmCham Guyana.
Thank you, Indar. Honorable Attorney General, Mr. Basil Williams, members of the Diplomatic Corps, former President, Mr. Donald Ramachar, Mr. Anil Nandlall, former Attorney General, and Mr. Ralph Ramkarran, former Speaker of the National Assembly, distinguished guests, and our viewers at home live on Facebook. I would just, first of all, let me say that it's indeed a privilege to have these distinguished gentlemen here with us today. The need for this forum today emanated from the membership of AmCham, many of whom had a lot of questions, a lot of concerns that we within AmCham could not answer. So what we did was that we gather up the best legal minds in our country, and we have them on stage with us today. So for all of you businessmen and women in the private sector, consider this a legal opinion, compliments of AmCham. And I do hope that our discussions today will focus less on the political side and more on the business side, right? What are the implications of the CCJ ruling on business? We would like to know from our panelists today, how should businesses interact with government and government agencies? Has the decisions of the CCJ have any effect on how businesses deal with government agencies and government themselves? How do investors treat this current period that we have? What happens if there is no election by September the 18th? Are there any implications for business, for investors? Those are the things that we would like to get answered today from our distinguished panelists. And we're very happy to have them here today, Mr. Moderate. And we also have Mr. Deodat Indar. He's the former Deputy Chairman of the Private Sector Commission and the President of the Georgetown Chamber of Commerce, and a businessman himself. And we would like to welcome him and thank him for chairing this session for us. So, Mr. Moderator, I will ask you to please ensure that our panelists stick to the time that have been allocated for them, and to also allow for questions from our audience and those on Facebook as well. So I'll hand it over to you. Thank you everyone for coming.
Thank you very much, Zulfi. Just some housekeeping issues before we go into the discussion. We will take questions from the floor after each of the member of the panelists. After each member of the panelists give at least a 7 minutes oral presentation. Then we'll go into questioning. The questioning will come from the floor. You will say who you are, and then you will say the question. I'm trying not to give long speeches. We are not here for that. We are here to get questions answered by the panelists. We will also field some questions from Facebook. We have the live stream running on Globespan 24/7. I will take some questions from those. Those will be handed to me, and I will then put that to the panelists for discussion. But the ones that comes from the floor, we are asking you to be very brief, very concise, and don't get into long speeches. We want the speeches to be from the gentleman on the stage. No disrespect intended. First, for those who are joining us around the globe via Facebook and live stream, what we have this afternoon is a lineup of some extremely brilliant leaders in Guyana. And first, I want to introduce Mr. Ralph Ramkarran. Mr. Ramkarran is the senior counsel and was the former Speaker of the National Assembly. So he is a pristine legal mind. Then we have next to him, we have Mr. Anil Nandalall or Mohabir Nandalall. Mr. Nandalall is a member of parliament and the former Attorney General of Guyana, Minister of Legal Affairs and Attorney General. And then we have to the extreme left of the table of the stage, we have the Honorable Basil Williams. He is the current Attorney General and Minister of Legal Affairs of Guyana, and he is also a senior counsel. So without further ado, I will first ask Mr. Ramkarran if he can go into his oral presentation, then followed by Anil and then Basil, and then we'll go to interactive question and answers. Thank you very much.
Good evening, ladies and gentlemen, Mr. Chairman, members of the head table, Honorable Attorney General, Your Excellencies, Mr. Donald Ramatar, former President, ladies and gentlemen. Having been a former politician and now a new politician, I'm not sure if I can stick to the 7 minutes. Politicians usually like to speak for long periods without restraint. I'll try my best, however, under these circumstances. I don't know anything about business. I do recall reading in the newspapers a few days ago that the Minister of Finance, Winston Jordan, said that the economy is likely to grow by 4.4% this year, which is not bad. And if that is achieved, then I presume that the speculation that is going on that the economy has slowed might not be true, might not be accurate. However, economic growth is one thing, but how the economy grows and in which area it grows is another matter. I noticed also that the minister said that it is not true that money has been sucked out of the economy by higher taxes. But I was struggling with the Bank of Guyana's quarterly report for the first quarter this year, this afternoon, in preparation for this event. And there's substantial figures reported in the Bank of Guyana report as monies which have been taken out of the economy by taxes. You can read it for yourself, it's there. So the minister might have been precipitate in his accusation against people who say that the taxes have been responsible for a slowdown, if there is a slowdown in the economy. There is anecdotal evidence on the street that things are bad, that business is bad, particularly the stores and so on, that nothing is happening and unemployment is increasing, money is not being spent. The government itself has difficulty in offloading monies and spending monies. So what the real situation is, I don't know. But it's normal and natural in times of crisis such as this in Guyana that the economy is adversely affected. And business people, I presume, want to know what is the situation today in terms of the political stability, if there is political stability, and if not, when it will return, having regard to the legal problems we face. One issue is whether the government is lawful today or not. Most people think it is, even though a valid no confidence motion was passed on the 21st of December 2018, and elections were supposed to be held on March the 21st, 2018. You will recall that the Chief Justice in a decision ruled that the no confidence motion was valid and elections should be held by March the 21st. There was an appeal of that decision in the Court of Appeal, and the CCJ described the events after that as having been on pause. No one knows what that means. I don't know if the Attorney General can explain it this afternoon, but we have no such concept anywhere on which we can rely to explain what the pause means, what a pause means in these circumstances. So anyway, nothing happened, and then the Court of Appeal ruled on the day after March the 21st that the no confidence motion was not valid, and therefore we returned to the status quo ante on December the 20th. The government was lawfully in power, in office. And that continued until June the 18th, when the Caribbean Court of Justice ruled, and they ruled that the no confidence motion was validly passed. Now there's a huge argument which is going on at the present time about whether the CCJ has fixed a date for the elections. Well, the judgment is there for you to read. We have, it has been published in the papers. I have written about it several times, quoted the passages and so on. The government argues that no date has been fixed for the holding of elections. So what does that mean? Does it mean that we can sit, twiddle our thumbs, waiting for the house-to-house registration to be over? All the house-to-house registrations since 1992 have taken 18 months. Wait for the house-to-house registration to be over, and then have elections, and nothing happens. The government can stay in power for as long as it wishes. Is that the situation? Or is the situation that the CCJ gave its decision on June the 18th, and elections are due on or before September the 18th? If elections are due on September the 18th, the house-to-house registration proceeds after September the 18th, what happens? Are we in a state of unlawful government in power after September the 18th? That is my view, but I don't think the Attorney General shares that view, or he has some other view, which I have been trying to grapple with all day. We were in court all morning, and I have an indication that that may be his view, but how it fits with logic, I'm yet to decipher. So what does the business community do? Do they sign contracts now? Are those contracts valid? Do they, will those contracts be valid after September the 18th? Could the National Assembly pass laws, approve orders after September the 18th? I don't believe they can. There are various devices which can potentially make them lawful, but after September the 18th, as my colleague Anil Nandalall said today, a very colorful phrase, I'll have to paraphrase it, that the ship of Guyana is in uncharted constitutional waters. He has the gift of lingo, so. The ship of Guyana is in uncharted constitutional waters. So nobody knows exactly what will be happening after September the 18th, if we are correct, that is the last day in which the government can remain lawfully in office. There are other complications. The president has said that he doesn't fix a date for elections, as quoted in the Stabrook News. That it's the Elections Commission has to fix the date for elections. Well, Article 61 of the Constitution says that the president fixes the date for elections. And Article 62 says that the Elections Commission supervises elections. So we really don't know what The Honorable Learned Attorney General is advising the President because he has advised the President already that the Cabinet does not have to resign. And Article 106 says that the Cabinet must resign upon the passing of a lawful order. But he said the CCJ didn't say that the Cabinet must resign. Well, the CCJ doesn't have to say so. What the CCJ said was 106 is plain. It's clear. Everybody can understand it. So we don't have to analyze it for you. You're big people. Analyze it for yourself and follow it. So I don't know if the Attorney General has advised the President that he is required to issue a proclamation dissolving Parliament and issuing another proclamation fixing a date for elections. The President said that he doesn't do those things. So we're relying on the Honorable Attorney General now when he returns to his office, if he hasn't done so already, to correct this situation and so that we can have these proclamations as early as possible. In the meantime, we have to wait until August the 14th, again, for the second time since December the 21st, we have to wait on August the 14th for the Chief Justice to rule on whether elections are due on or before September the 18th, and whether the house-to-house registration going on now is lawful or not. So we are about to have another round of court cases to decide what the lawyers started out in January asking the courts to do, asking the Chief Justice to declare when elections are due, and asking the CCJ. And onto this day, the courts are declining to instruct the executive, except in vague terms, what they must do. Thank you.
Thank you very much, Senior Counsel. So you took 11 minutes. So for the rest of panelists, you have to be afforded the same amount of time, right? So at least I will give you a little indication when the 11 minutes is about to be up. I know you guys want to give as much as you can, but we got to make sure everybody get the right amount of allocated time. Thank you. Mr. Anil Nandalall, thank you very much.
Ladies and gentlemen, good afternoon. It is impossible to examine the question posed. That is, what are the consequences or implications of the consequential ruling of the CCJ on business in Guyana without examining the conduct that led to the consequential orders being made, the conduct of the government, the executive, because that bears a strong connection with the implications on business in Guyana. And that is why in my presentation, Mr. Moderator, I ask your permission to defy you, because I'll be a little long, because I want to examine it for the benefit of the audience and give my take on it, how we have arrived here. It is now recognized as a fundamental truth that there is an inexorable causal nexus between the rule of law and economic and social progress in any given society. A most peripheral glance around the globe will result in the ineluctable conclusion that nations which subscribe to the rule of law and whose legal system is strong, flourishing, competent, and respected are the nations that flourish economically and in turn socially. Therefore, it can hardly be disputed that obeisance to the rule of law is a sine qua non of development. The rule of law is a multidimensional concept, but a strong independent judiciary whose decisions bind those to whom they relate, constitutional compliance, adherence to the doctrine of separation of powers, respect for the inalienable basic human rights of the citizenry, and a culture of respect for the laws of the land generally are indispensable ingredient of that aggregated concept commonly referred to as the rule of law. One famous Indian jurist, V.G. Ramchandran, views the rule of law as the cornerstone of civilized life itself, and the last bulwark of a state is its court of justice. In the free world today, wherever responsible government exists, concept of special respect to the seat of justice, attendant with punishment in the case of contumacious behavior, prevails. A no-confidence motion is a permanent feature in the democratic architecture of constitutions in the world over. The first no-confidence motion in recorded English history was passed in the House of Commons against Her Majesty's government nearly 250 years ago. When British granted independence to its over 50 odd colonies, it inserted in their constitutional instruments, drafted at Westminster, a power in their parliaments to pass a no-confidence motion against their sitting governments, with the uniform consequences that the government would have lost the support of the people and must return to the electorate within a time specified, either for a renewal of its mandate or for a new government to take its place. My research informs me that no confidence motions were passed in India, Canada, the United States, in several African countries, Australia, and of course right here in the Caribbean. In its over 250 years of parliamentary democracy, there is no recorded instance where a government has refused to abide by the constitutional consequences of a no confidence motion being passed until December the 21st, 2018, in the Cooperative Republic of Guyana, South America. An unenviable distinction indeed. Articles 106.6 and 106.7 of the Constitution are expressed in language whose simplicity and clarity can hardly be disputed by the rational mind. It reads thus, 106.6, the Cabinet, including the President, shall resign if the government is defeated by the vote of a majority of all the elected members of the National Assembly on a vote of no confidence. Absolutely straightforward, absolutely simple. 106.7, notwithstanding its defeat, the government shall remain in office and shall hold an election within 3 months or such longer period as the National Assembly shall by resolution supported by not less than 2/3 of the votes of all elected members of the National Assembly determine, and shall resign after the new president take the oath of office following the elections. Again, no room for ambiguity. Despite their clarity and simplicity, these two constitutional provisions have violently lacerated the mental psyche of this nation for the past 8 months. Only last Friday, no other than the Attorney General of the land argues before the Chief Justice that there is no need for Cabinet to resign. It does not require the acumen of a genius to conclude that it is this type of extraordinary legal advice that the government receives which results in me speaking to you this evening. It is now a fact of public notoriety that a no confidence motion passed since December the 21st, that the no confidence motion was passed since December the 21st, 2018, and accordingly, Articles 106.6 and 106.7 were immediately triggered. To every rational mind, the government was defeated. The cabinet, inclusive of the president, was required to resign A date for elections was required to be fixed within 3 months thereof, and the government was to remain in office with limited powers until a new president is elected. As I said, those consequences were clear to every rational mind, but not those in government. They took the unprecedented move of returning to the Speaker to ask him to reconsider the vote. Naturally, he refused to do so, for he had no authority to do so. In contumacious defiance and indeed willful disobedience to the clear language of the Constitution, they ran to the judiciary for respite. The Honorable Chief Justice rejected them. Her Honor upheld the validity of the no confidence motion and ruled that Cabinet, inclusive of the President, was resigned on December the 21st, 2018, and the other prescriptions outlined in Article 106.6 and 106.7 of the Constitution must be carried out. The government obdurately refused to comply with the Chief Justice's ruling and launched appeals against it. They were able to persuade the Court of Appeal in a 2-to-1 judgment that 33 votes did not constitute a majority of 65 of the members of the National Assembly, and therefore the no confidence motion was not carried. Then the matter went to the Caribbean Court of Justice. And on June the 18th, the court delivered its decision. It invited all the parties, and in that decision, of course, it upheld the Chief Justice's ruling and ruled that the no confidence motion was validly passed. The court then invited all the parties to make submissions in terms of what orders it should make consequential upon that decision, which it delivered on June the 18th. Now, in the interregnum, there were important events that I must highlight. On June the 12th, while we are awaiting for the CCJ to hand down its decision, GCOM, by an order, decides to launch house-to-house registration. The court decision was already fixed. That did not stop GCOM, a party to the proceedings, to launch a process precipitously and in disregard for how the court will rule, a process that will put one and put the government in a collision course with the Constitution, were the Chief Justice to uphold, were the CCJ to uphold the Chief Justice's ruling. July the 12th, the CCJ issued its consequential orders. The relevant orders were that the National Assembly properly passed a motion of no confidence in the government on the 21st of December 2018. Upon the passage of this motion of no confidence in the government, the clear provisions of Article 106 became immediately engaged. Notwithstanding that, and we know what Article 106 says, election must be held within 3 months. GCOM then, on July the 20th, days after this, begins the house-to-house process, a process that by GCOM's own timeline is scheduled to take us until December. And they started it from their own timeline, which was supposed to begin on the 2nd of June. They started it on the 20th of July, 48 days later. So when their schedule says that it will end on December the 20th, you now have to add 48 days to that. That will take us to February thereabout. That's just for the process to be completed. And this is an organization, GCOM, that is bound by the Constitution and is a party to the case. And let me quote briefly from the decision of the CCJ, the rulings of the CCJ rather. On the very July the 12th, the CCJ said this: the judiciary interprets the Constitution. But as we intimated in our earlier judgment, these particular provisions require no gloss on the part of the court in order to render them intelligible and workable. Their meaning is clear, and it is the responsibility of the constitutional actors in Guyana to honor them. Upon the passage of a vote of no confidence, the article requires the resignation of cabinet, including the president. That's what CCJ said. The article includes the resignation of cabinet, including the president. But you heard earlier that the Attorney General says that that's not so. The article goes on to state, among other things, that notwithstanding such resignation, the government shall remain in office, and that an election shall be held within 3 months or such longer period as the National Assembly shall by resolution, supported by 2/3 majority, etc. The Guyana Elections Commission has the responsibility to conduct that election, and GCOM too must abide by the provisions of the Constitution. That is what the court said. You cannot get it in clearer language than that. But despite all of this, GCOM embarks on a process in clear defiance of the pellucid language of the court. And this is where the CCJ, in my humble view, fell into error. This is what they said. Article 106 of the Constitution invests in the President and the National Assembly and implicitly GCOM responsibilities that impact on the precise timing of elections which must be held. It would therefore not be right for the court, by issuance of coercive order or detailed directives, to presume to instruct these bodies on how they must act, thereby preempting them in the performance by them of their constitutional responsibility. The court will assume that these bodies and personages will exercise their responsibilities with integrity and in keeping with the unambiguous provisions of the Constitution. Clearly here, the court made a mistake in trying to project what they feel of these personages that they're referring to. They believe that they're speaking to personages that has a propensity to obey the Constitution. But we were before the court because they were not obeying the Constitution in the first place. And here's where the court made the error. And we are in the situation that we are in now because we provided time frames for the court to make orders, and it declined, relying on the goodness of the constitutional actors in this country. Well, the court clearly, its confidence was misplaced. Notwithstanding these clear, crystal pronouncements from the highest court in the land, Cabinet is yet to resign. And the learned Attorney General says Cabinet does not have to resign. The President has not yet dissolved Parliament and has not yet fixed a date for elections. Meanwhile, GCOM is proceeding merrily with a house-to-house registration process that will put possible elections until mid-2020. The only opposition party in the Parliament has signaled an intention not to return to the National Assembly to extend the life of the Parliament and has called on its supporters to boycott the house-to-house registration process. In short, the state of Guyana is precariously perched on the precipice of a constitutional crisis. After September the 18th, the government will lose its constitutional right to govern, and Guyana will become no longer under constitutional rule, but under tyrannical rule. This will sound the death knell of the rule of law. Logically, the economic and social progress which the rule of law guarantees will certainly dissipate. The downward slide has already begun, and that is why I detailed the behavior which led to the consequential orders, because that must be taken into account, because that by itself affected the climate, the business and economic climate in the country. I will make reference, the downward slide has already begun. I'll make reference to empirical data in due course to support this contention. But it is important that I digress momentarily to make the point that the consequential orders of CCJ must not be viewed in isolation in respect of the abrogation of the rule of law and constitutional defiance on the part of the government. It is simply a culmination of almost 4 years of flagrant disregard for the Constitution and the rule of law by the government. No prudent investor will invest in a country where the government is unlawful, where the government disobeys the Constitution and the laws of the land, and disregard its own court's decision. Those are all manifestations of a political culture of intolerance, authoritarianism, lack of democracy, and a society where private capital, investments, and private property are unsafe and insecure. As I said above, this toxic political climate has already begun to negatively affect economic activities across this land. From all indication, the situation will only get progressively worse. Not surprisingly, the Caribbean Development Bank earlier this year issued this ominous warning. I quote, "While Guyana is on the verge of sharp increase in economic growth, its prospects depend on ending political uncertainty," unquote. In similar vein, the Georgetown Chamber of Commerce has publicly disclosed that a survey that it did showed sharp decline in business and commerce since the no confidence motion was passed. The Private Sector Commission has repeatedly complained of the devastating impacts the political climate has had on the business community and in particular investors' confidence since the passing of the no confidence motion. Currently, the government is limping along with a caretaker status only. This means that the government cannot implement new policies, cannot pass a budget, cannot enter into new contracts of worth, cannot embark upon new projects, and cannot enter into new international treaties. At the national level, the government is the largest spender in the local economy. With its current limitations, it can only spend in relation to routine goods and services. This is a significant blow to economic activities locally. Tens of thousands depend upon projects and contracts from the government for their livelihood. The government cannot execute these contracts in its current state. Naturally, no new investors will come because the government cannot enter into lawful contracts with them. I must emphasize that all of this are taking place while the government still enjoys some degree of legitimacy. This flimsy constitutional lingerie of legality will be ripped off on September the 18th, and the government will become completely denuded of any form of constitutional and legal attire. After that, the ship that is Guyana will then drift into uncharted waters where none is wiser in relation to what the eventuality holds. Certainly, we will be joining that inglorious group of nations ostracized by and from the free world. I hear some arguing that the doctrine of necessity can come to our rescue. I reject that proposition as wholly without merit. The doctrine of necessity can only be properly activated when there has been an intervention of an event unforeseen, unpredictable, and unpreventable. It cannot and will not apply where the executive willfully violates the verdict of its own legislature, intentionally tramples upon its own constitution, and deliberately disobeys its own judiciary, thereby catapulting the nation into constitutional crisis. For if the doctrine of necessity can be invoked in such circumstances, it would have been the refuge of every tyrant who refuses to call elections when they become lawfully due and then utilizes the doctrine of necessity to remain in government ad infinitum. In conclusion, the consequential orders of the CCJ has simply created a platform for us to see the type of environment that the government is prepared to create and the government is prepared to expose the country to. The business class, the economy, commercial activity are not exempted. They are exposed as everyone else. As I said, after September the 18th, I don't know what will happen. The Constitution will be of no use to us anymore because we would have the constitutional tenure, the time frames of the Constitution, the provisions of the Constitution would have no applicability to the situation that will then prevail. So I conclude at this juncture by saying it's not the consequential orders that have implications for business. It is those who are refusing to execute and comply with those constitutional orders that are exposing the business community and the economic climate of this country to the hazards that they are now exposed. Thank you very much.
Thank you, Mr. Nandalall. Well, according to my Samsung clock, you took 20 minutes. So, Honorable Attorney General, Mr. Basil Williams, your turn, sir.
Good evening, Master of Ceremonies. All protocols having been observed. I'm happy for the occasion presented this evening by the American Chamber, and it gives me the opportunity to really show you what the true position is and to assist you to differentiate between fact and fiction, rhetoric, and what really is the legal position in Guyana. If I might preamble, though, there was a treacherous act which came 3.5 years into our term. We had, in fact, embarked upon the transformation of Guyana. Guyana was a pariah state when we took office. It was a narco state. We've implemented measures to roll back the narcos, the money launderers, and the like, the corrupt ones. And we've been cleaning our economy of dirty money. We've transformed the city. We've made the city clean again. We've given Guyanese hope again. Guyanese could walk proud in the world, in this region. We are well respected for the policies that we have adopted. But for the intervention by one we had embraced, by one person who frustrated the 200+ votes that were given to the APNU AFC government. So all this law that we hear that has flowed, really, one would have hoped it would have been from a more loftier element rather than from the element of treachery. But you know, treachery has its difficulties, and that's why perhaps how things eventuated, we're still here trying to grapple with what was called a no confidence motion. It was unprecedented. And I would say that in our constitution, which came after a referendum, the framers of the constitution and the people of Guyana did not see it fit to include in that constitution in 1980 any provision for no confidence motion. In fact, the no confidence motion provision was inserted in 2000. Hurriedly, without much thought. They didn't put in a structure, they didn't put in an infrastructure to enable a snap election to be held in Guyana. Other countries that have provisions in no confidence motion, they walk you through the procedures to take you there. What did we have? A provision saying the government shall hold elections. From the outset, I spoke about the absurdity of the provision. And quietly in the judgment in the CCJ, in paragraph 5, I think it was, the court quietly agreed with me that it is GCOM that has to conduct elections in Guyana. So the provisions had their difficulties, and we went to the speaker to seek clarification. The speaker acknowledged that he could revisit his ruling, but he felt that the constitutional issues that I had raised were of such a nature that they should go to the body that has a remit to interpret the Constitution. And so the Speaker referred us to the courts. And we have a right to go to the courts because we are a law-abiding country, a law-abiding government. And no less a person than the President himself has always maintained that we will obey court orders, and we are obeying court orders. So it is erroneous to suggest that we are in breach of the Constitution, we are not resigning, etc. And I think, to me, it's insultive to the CCJ, the apex court, to actually disavow its ruling and apply all kinds of tenditious thoughts to what the people actually ruled. And so let me try to clarify that issue in this context. And let me say to the chamber, Guyana is the fastest growing of 5 fastest growing countries in the world, our economy. And we are not saying that as a government. You know who said that. And so all of this doomsday sayings that and utterances that we have about our government, I don't know where it's coming from. But you cannot be the fastest growing economy in the world and you're saying that there's a downturn in our economy. All of the business that is being given out in connection with oil and gas, all that spending is impacting the economy. And therefore, it is fallacious to allege that there's a downturn in business. So, what happened? The first court of first instance, presided over by the Honorable Chief Justice, Roxanne George, she ruled against our application that the vote was not properly carried. Fair enough. We have a hierarchical system of courts. So we don't have to stop at the first instance court. And so we went forward to the Court of Appeal, and we won there. The opposition didn't stop there. They went to the CCJ, our apex court. And when they went to the CCJ, the court ruled that the motion was carried, etc. But that was only the first part of it. The question was, what orders should the court make? What consequential orders? And so the court invited all of us. The court joined GCOM, by the way, at the Court of Appeal. At the CCJ, they joined GCOM. And GCOM submitted what its program was, etc. You all of us heard it. It was live. They talked about Christmas Day on one part, etc. So all these things were put before the CCJ, all of them. But in particular, the leader of the opposition, and he was supported by the other appellants, Charandas Prasad, Christopher Ram, etc. They put to the court and they asked the court to grant these consequential orders. One, that the cabinet, including the president, shall resign. Two, the government shall remain in office and shall hold an election for members of the National Assembly within 3 months. Within 3 months of 18th of June, 2019. 3, in order to facilitate such an election, the president shall by proclamation appoint a date for the holding of the said election no later than the 18th of September 2019. And you've been hearing a lot about 18th of September being a drop dead date. They're actually mirroring what they were saying about March 21st, about being a drop dead date. And remember, my good friends dropped dead on the 22nd. But the fourth thing they asked was that the official list of electors to be used, and this is important, at the said elections shall be the official list of electors produced pursuant to Order Number 15 of 2018 with a qualifying date of the 31st of October 2018. This is the list of 30th of April, which would have lapsed or expired after 6 months. All of these questions and orders were sought from the CCJ. What was the ruling of the CCJ? The CCJ ruled in relation that the cabinet, including the president, shall resign. In refusing this order, Chief Justice Saunders, President of the Court, at paragraph 7 of the no confidence motion said, and I quote, Article 106 envisages that the tenure in office of the cabinet, including the president, after the government's defeat, is on a different footing from that which existed prior to the vote of no confidence. I repeat, the CCJ ruled that Article 106 envisages that the tenure in office of the cabinet, including the president, after the government's defeat, is on a different footing from that which existed prior to the vote of no confidence. And that's where we are right now from where I stand. What was this different footing? Chief Justice Saunders referred to the judgment of the Chancellor, the Lord Chancellor in the Court of Appeal, in the no confidence motions, where the Lord Chancellor relied on the constitutional expert in Canada, in his book, the Constitutional Law of Canada. And Justice Common Edwards, in saying this is what the Chief Justice Saunders said. Chancellor Commons Edwards was right to note that the government continues in office as a caretaker government or an interim government until the next elections ensue and a president is appointed or reappointed, depending on the results of that election. So, to me, I'm wondering what is going on in the mind of the Lord Chief Justice and President of the CCJ. To hear the lawyers who were before him completely distort the solid reasoning that he put out in the court. In fact, what we have now is a most anomalous situation where the lowest court in our structure is sitting on review and has been asked to sit on review of the decision of the apex court. So it's turning the whole system upside down. But of course, we know that good faith will prevail in the matter. And in fact, we raised the whole question of res judicata. The law is you cannot relitigate issues that have been determined finally in the highest court. You have a duty to put your whole case to the court. So you can't come to a first instance judge and ask them to relitigate decisions made clearly by the CCJ, the highest court in our land. And so all of this, the type of disinformation, fake information, it ought to stop because it does no well for the country. You know that we are properly in office. We are there as an interim government. We have acknowledged that. We only could do routine matters, and I respectfully submit right now that in dealings with the chamber, they largely deal with commercial contracts, and there's nothing stopping them from entering into commercial contracts. It's the big Amila Falls-like contracts you have to avoid. Giving out blocks, oil blocks, you have to avoid. All these things were done by this government, the opposition, just a week or two before they left office. So, and I'm going to deal with that. I'm going to deal with that, and you're going to come to the root of the matter in that case. Because we must put an end to corruption in this country. So, The second thing they asked for is that the government shall remain in office and shall hold an election for members of the National Assembly within 3 months of 18th of June. That was when the decision was given in the CCJ. They continue, in order to facilitate such an election, the president shall by proclamation appoint a date for holding of the said election, no later than the 18th of September. So I want to make it clear. They directly asked the CCJ to rule that or give a date for elections on or before the 18th of September. That's what they did. And what did the CCJ rule? The CCJ rejected the request for those orders. The court said this: the Ghana Elections Commission, GCOM, has the responsibility to conduct elections. And I'm saying that I said this, some quote from the first instance judge, I'd said that. So I was happy to see that the court finally agreed it's not the government to hold elections, but it's GCOM. Secondly, Chief Justice Saunders, President of the court, at paragraph 7 of the no confidence motion judgment expressed thus, and I quote, Article 106 of the Constitution invests in the President and the National Assembly and implicitly in GCOM responsibilities that impact on the precise timing of the elections which must be held. It would not therefore be right for the court, by the issuance of coercive orders or detailed directives, to presume to instruct these bodies on how they must act and thereby preempt the performance by them of their constitutional responsibilities. They said it would not be presumptuous to preempt the President, the National Assembly, and GCOM as to how they must go about their business. And they continue. It is not, for example, the role of the court to establish a date. I repeat, Chief Justice Saunders said, it is not the role of the court to fix a date or by which the elections, to establish a date on or by which the elections must be held. So that refers to the president, because under the Constitution, powers in him to fix a date under Article 61 by proclamation. He also has the power to dissolve Parliament by under Article 72 of the Constitution. So they say they're not fixing the date. That's the president's remit. They continue. Or to lay down timelines, and deadlines. Exactly what is being asked in the High Court. Fix a date in 3 months. Give them a timeline of 3 months. Give them a deadline of 3 months. Give them a deadline of no later than the 18th of September. I don't even know where they got that from. So these things were frontally dealt with by the CCJ, and they refused to grant those orders. And this is what the court continued to say. They're not fixing timelines and deadlines that in principle are the preserve of political actors guided by constitutional imperatives. The court must assume that these bodies and personages will exercise their responsibility with integrity and in keeping with the provision of the Constitution. So there's nothing here where the court said anything that they fix a timeline or a date for elections in Guyana. Nothing. So it's erroneous to suggest, and for Mr. Nandalall to suggest, and the opposition to suggest, that the 18th of September is the drop dead date. And of course, my good friend, Mr. Ramkarran. They've got it wrong. They've gotten it wrong on this occasion. So what is the reason and the basis for the Chief Justice's decision in the court of CCJ? What the court did was actually to apply the principle of the doctrine of the separation of powers. This self-same judge, when he was a puisne judge or a judge of first instance in Anguilla, where his brilliance had started to show, he gave a seminal judgment in the case of Benjamin and Attorney General of Antigua. And he outlined clearly the doctrine of the separation of powers. And he said that the court itself must not overstep into the realm of the executive or the legislature. And I was watching to see how the CCJ was going to approach this issue. Because as long ago in 1970 in Hines and R, the Privy Council decision coming out of Jamaica, Lord Diplock said that in the context of where the challenge was to an act they said was in collision with the Constitution, he said that all that the court could do in such a challenge is to look to see whether the constitutional prescriptions were followed, and that is the procedural prescription for the passage of the legislation, whether it was passed with the requisite majority. But it could not be concerned with the policy or the contents of the legislation. That was not for the court. That was for the executive. So the court cannot enter into the realm of policy and the political. And so the CCJ held fast to the doctrine and said they would not enter into the political arena. And what would it look? There must be certainty in the law, and the court must not act in vain. What if the court were to deign to fix a date? They fix the date, and then the date arises, and there's nothing, they're not in a state of readiness. What happens? The court is embarrassed. It is a fundamental thing. The court ought not to enter into the realm of politics. You leave that to the constitutional actors. And as you say, you expect that they would act with integrity. Now, the constitutional actors have acted. On 2 occasions, we had to go to the court. The issue was looming large, like this, they're not meeting, they're not doing this, they're not doing that, and they met. And then subsequently, they agreed a new chairperson for GCOM. And in his judgment, Chief Justice Saunders said that Parliament could grant an extension by a two-thirds majority, and that Parliament had not done so as yet. So why is it impossible for the 2 men, mutatis mutandis in the case of the chairman of GCOM, to do the same thing now and return to Parliament and get the extension? But let me explain the extension to you now. I had always argued that this elections in 3 months couldn't be mandatory, could only be directory. Why is that? If it were mandatory and you didn't make the 3 months, it means you could never hold elections again in Guyana. And I think Justice Anderson agreed with me in the CCJ. The lawyer for the opposition leader agreed with me at the CCJ that yes, it is directory. So what happens if you don't make the 3 months, as happened here? There was no breach by the government. You can't be in breach and you pursuing your legal and exhausting your legal remedies. They said if you couldn't make the 3 months, you could have an extension by two-thirds majority. There's nothing in the Constitution that says the extension that you could get must be another 3 months. There's no limit put inside the extension, and it makes good sense. Because if you go to Parliament to get a 2/3, it is clear that the constitutional actors have to be engaged. The President, the Parliament, and the Leader of the Opposition, and GCOM. They all have to sit around the table and arrive at a definitive date. And that date could take you past 3 months. And when they arrive at that date, you go to Parliament and you get a 2/3 extension. And you run with it. Now that's what the CCJ expects. That the maturity within here in these constitutional actors, they get together, sit around the table, and I'm saying they have done it already. And it's not impossible. But even if, let's assume they don't do it, they don't go and get the 2/3 extension. I don't know where this argument came about necessity and all that. I think that was only heard today. I heard that introduced today by Mr. Nandlall. But we have always argued in the CCJ, this scenario, if you don't make the 3 months and the 3 months had been passed, you have to go and get the 2/3 extension. If you don't get the 2/3 extension, you're under the regime of 1066 and 1067. What does that regime say? That the President shall remain in government until a President is sworn in or reappointed after the election. So in the context of 1066 and 1067, you have the President. And so it would have to now fall to the President, who, as I said earlier, has the power to fix the date for election by proclamation and the power to dissolve Parliament. There's no constitutional crisis and all of that. And I don't know about tyranny. We saw the last government prorogue Parliament for almost a year. Parliament for almost a year to avoid a no confidence motion. And you know what? That was right up their bailiwick. One party rule. The whole communist approach, common Marxist Leninist, that was right up in their street. They're running Guyana from Freedom House in Robb Street. That happened in this country. And so when they think they're ready for election, they came out and they got the Licks of Lisbon. And I don't know why they feel that they must get back into power. The people put you out. It's a new day. It's a new day. They want a transformation of this economy. They want everybody to benefit from the patrimony of this country. Not cronies, families, and friends. All Guyanese. And that is our promise to this nation. Every Guyanese must have the opportunity for a good life. And we were well on our way. We're very confident in these elections. I don't know what's the big noise about. But we have to go to the elections. If the immediate past chairman of GCOM has invaded against the sanctity of the list, why not have a proper list? That's the only way you could have a credible election. And as I'm on this list, my learned friend argued that it's unlawful for GCOM to embark on house-to-house registration to arrive at a brand new list. That is a brand new national register of registrants. And as I showed him, as I showed the court today, that GCOM has the constitutional remit to compile a register or to revise a register. Article 159.5 of the Constitution. And so, if you're compiling a register, it has to be a brand new register. You can only revise an existing register. And that's why Mr. Mendez, lawyer for the leader of the opposition in the CCJ, was asking to use that imperfect list, that imperfect register of the 30th of April 2019, with all its imperfections. The best route, and this is another point, in 2005, continuous registration was introduced. For you to have continuous registration, you have to have a register. But they didn't go house to house to create a new register or compile it. What they did, they deemed that the 2001 database would be the register for 2005. And what they did next? They made provision for office-based registration. So you have a list, and what they did is to allow open offices around Guyana so that people could go and apply for registration. But you know what? It transpired that that was one of the most inefficient ways to have registration done, because people just weren't going. They just weren't going. And you know, it's an offense for you not to register. So what happened then, since that happened in 2005, that list is start doing continuous registration, which is updating periodically. In 2007, there was a bill taken to Parliament, I think it's number 27 of 2007, and the explanatory memorandum said, the thrust of this bill requires house-to-house registration for local government and general elections. Now, what is trust? Obviously, it's a new paradigm, because don't forget the continuous registration was office-based. So they decided now, look, we have to straighten out this registration thing. And so they had Section 6.4, they introduced Section 6.4AA, which made provision for the registrars to go around and get the registration by house-to-house visits of persons over the age of 14. I haven't reached 20 minutes yet, I'm sure. Oh, really? Okay, I will leave the rest then in there. But I think you could give me the privileges to end off. Yes. And so what is happening is that GCOM embarked on a lawful exercise. They had agreed every 10 years they would refresh. And that's why in 2008, an order was passed to house-to-house registration, which was conducted and a new register compiled. And Section 9 says that a register will be created from the house-to-house registration, and upon which continuous registration would be applied. And that's all that has been happening since 2008 to now. And in 2018, 10 years later, they also passed another order for house-to-house. Nobody contemplated no confidence motion and all of that. As I said, this country was not equipped for a snap election. And we now have to go back to Parliament and seriously look at the legislation to effect that. That's what we have to do. But in the interim, all Guyanese would want a credible election. We don't want no problems. You don't want people go to vote in Georgetown. You discover that they're supposed to vote in a scribble and all that. Yeah, you know, it's the only way to clean the list. No one is disenfranchised because the Constitution authorizes it. So if you're not at a house, you're not resident at a house, you can't be on the list. Because we banned overseas legislation in around 1990 when President Carter came. We don't have overseas voting except for diplomatic staff. So you have to be resident at the qualifying date in Guyana, in a registration division. And all that's provided for under Article 159(2)(c), which said the Parliament could prescribe additional qualifications, and that was done in the National Registration Act and also in the Representation of the People Act. So, you know me, when I get warmed up, it's hard to take me off the podium, but I would respect the rules of the House, and I'm not delay you any further. Thank you very much for listening to me.
So I told Zulfikar, when you get lawyers and they start to talk, it's difficult to get them to stop. So I was going to get like a little hammer something down there, but he said we should give free rein. Nevertheless, we have one mic there, and we are looking for questions from the floor. There's a mic there, gentlemen, under the head table there. You'll have to share that and direct your question to exactly who you want your answer to, and I'm sure e- whoever could get a bite of the question will respond from the table. So, first question. The mic there, sir. Go to the front. Please say who you are and your question, sir.
My name is Rafik, President of the Central Quarantine Chamber of Commerce. That's Borbis. I have my colleague here with me from Amsterdam, the Borbis Chamber in Amsterdam. Sitting there listening to our AG made me wonder if I was in Guyana or the two of us are living in two different countries. I would just like to say, gentlemen and ladies and gentlemen in this room, I'm not a politician. I don't belong to a political party. I'm a businessman. I live in Borbis, where business has gone down by about 30-35% this year in comparable to last year. Where over 5,000 people lost their jobs, and nothing seems to be happening in that part of the country. This no confidence motion in December the 24th seems to have put this country in a standstill. As a businessman, I cannot really, my mind is not focused on what I should do. All I keep looking and reading the news and see when we're going to solve these problems in Guyana. Look, I went to school and I can read, I can comprehend, and I can understand these simple. According to the CCJ, as per the Constitution, in 90 days. I do not need anybody to come and insult my intelligence by telling me this is directory and that is directory. I know that, look, we have a no confidence motion in the country. What do? We go to elections. It is as simple as that. Now, I get the impression, the AG said, okay, I'm going to put my question now. He said, the no confidence motion is treachery. Now, I would like the AG to explain to me, why did he say a no confidence motion, which is in our constitution, is treachery? And I would like to tell him to explain to me, why is a no confidence motion on the constitution when the government can have an open-ended way of running the country 1-2 years after the no confidence motion? Thank you.
Thank you for your question, Mr. Rafik. AG, would you like to respond to that, sir? He's asking, I'm sure you heard what he said. Yeah.
Yes, but listen, you know, our position is that our policies have started to kick in. We will clean the economy from the dirty money. The dirty money can't come in as it used to. Narco trafficking is more difficult. So you can't get, you know, businesses, there's now a level playing field for businesses in Guyana. Because with the narco money, they push legitimate businesses out. That's what they did. They could have brought in the goods cheaper and on the sale. They could air condition the places, they could do all kinds of things, and the honest, law-abiding businessman couldn't make the grade with that. The imports are stifled on the wharves, all these things. I mean, we need to have a serious change in this country so that businesses, everyone who wants to be a business person must have a level chance of doing that. And the question of treachery, if you don't understand what treachery is, you know, you just told me you're educated and you don't need lawyers. So I'm surprised you asked me to tell you what treachery is. Treachery is when you are brought into an embrace in a fold and you give undertakings to abide by the principles and the objectives of this fold, and then you turn on them. You turn on these principles and objectives. You understand what that is. One person who decided that he wanted to roll back what was democratically put in place. That is treachery. It's equivalent to a Judas Iscariot. That is what treachery is. Betrayal.
Rafik, you finished your AG? Thank you. Could we have another question, and maybe Anil and Ralph, if you guys want to respond to that on the other question, is okay. But could we have another question from the floor? Go ahead, Paul.
Paul Tennessee from the Roraima Institute. I think it's lamentable that we are here today because since political independence to 1992, we were supposed to have resolved the question of verifiable, free and fair elections in Guyana. Nearly 3 generations since political independence. Are we going to be here 3 generations from now on the same issue? The International Monetary Fund in the spring designed some of the researchers something called the World Uncertainty Index. And the purpose for that is because we live in a world of turbulence. I also have been conducting listening interviews here in Guyana from 2017 to now, and over the last 4 weeks about the election. Uncertainty is in the minds of our citizens, whether it be the private sector or households.
And the question, sir?
Yeah, my question is, the only way we can address uncertainty for the business people and the citizens is if these gentlemen can identify at least three possibilities or indicators that we will have a verifiable, free and fair election in Guyana.
Thank you. Anil, you want to take that since AG had the last question?
Thank you very much. Look, a no confidence motion, in England there is no constitution. As I said, a no confidence motion exists 250 years ago in England. In India, no confidence motion is expressed in a single sentence in the English constitution. Here, you heard the Attorney General. The Constitution of Guyana dedicates 2 entire paragraphs to a no confidence motion. Yet, they say it's not enough. It's not enough, it's unclear. The consequences are all sorts of, I am so sick and tired of this thing. You can have verifiable elections, sir, as the chief elections officer told the media only last week, by the list going through a period of claims and objection. We can extend the time. The very list that they find so objectionable is the list under which they won a majority in 2011 elections, and they won the government in 2015, and they held 2 local government elections under that very list without a singular complaint about its lack of integrity. Suddenly this list is bloated, and you hear Blowenfield said it's not. What you are seeing here, ladies and gentlemen, is a callous disregard for the rule of law, an intolerance for constitutional compliance, and authoritarianism. different guises. None of you here started business since 2015. You were businessmen before 2015. So all of you were engaged in dirty money? Were your businesses engaged in dirty money? Who is the Attorney General referring to when he speaks about dirty money that he had to clean up? It's you, all of you. All of you are businesses before 2015. But this is the kind of plurality that we have to, it's not fair to the people of this country. It is not fair to the people of this country. But that is what we have to face as a people. And the quicker we understand that as a collective, the quicker we will get elections that Paul is speaking about.
Mr. Ramkarran, thank you, sir.
Thank you. I just want to say that in Guyana there was no, as Basil mentioned when he was speaking, there was no confidence motion in the 1966 Constitution, our independence Constitution, or in the 1980 Constitution. What we relied on was a convention that was as strong as a law. If in Parliament there is a vote of no confidence, or if the government lost a vote on an important matter, the government was expected to resign and to call elections. If, for example, the government lost a vote on a budget, for example, it would not have money to run the country for the following year, and therefore, of necessity, it had to resign. But if it lost also on another important matter, it was expected to resign. In 1999, when the issue arose, the PPP was in office. And the issue was not proposed by the PPP. There were many members of the elections, the Constitutional Reform Commission, who are not PPP. The PNC was represented on the commission, strongly represented. And each party had its allies. Now, the proposal for a no confidence motion came from the PNC members or one of their allies. And it was directed against the PPP government because they felt that if there was a no confidence vote without a law, that the PPP would not honor such a vote. And that was why the no confidence motion was proposed. The PPP accepted the motion, and I had to fight for it. Donald is here, he can tell you. They were all very suspicious of this proposal for a no confidence motion, but I suggested that if this was a convention as strong as a law, then you have to support it. There's no problem in supporting it. The PPP came around, and the no confidence motion was supported almost unanimously. Now, if on December the 21st, there was no confidence provision in the Constitution, and there was a vote say, right at that time there was a budget debate, there was a vote say Charnas Prasad had voted against the budget. Could you imagine what would have happened if there was no confidence motion and the government's budget was voted down? Maybe Basil can tell us what would have happened in those circumstances.
Anyway, can we have another question on the floor? I see the gentleman right there raise his hand. Yes, sir. Go ahead. You're going to go after him. Justin.
Good afternoon. All protocols being observed. I'm Dr. Dawn Stewart, and I have a question in reference to, I came with the intention to hear about what are the consequences to businesses in reference to the CCJ ruling. I've yet to hear that. I've heard a whole lot of ramification and a whole lot of jargon that I've been listening to for the last couple of months in reference to political agendas, but there has been nothing specifically outlining what happens in this business environment. I've heard words of the CCJ, and I've heard the interpretation, and I've heard what people want me to interpret as a business person as the consequences of this vote. I've yet to heard specific facts on what is it that is affecting the economy. I've heard the New York Times and the United States has published of the growing economy in Guyana and business investments in Guyana. But yet today I sit here and hear gloom and doom, and I want to know exactly if they can go through it step by step for idiot like me to understand what is it, how is it the economy is projected now to be affected by the no confidence vote.
Thank you very much for your question, ma'am. Gentlemen, which one do you want to go that out first? So Anil will go first.
Well, in my presentation, I alluded several times to the connection between constitutionality, legality, a society being governed by rule of law, and economic and social progress. And we are now careening into an arena of unconstitutionality. As I said, we are perched on that precipice. Any rational mind reading the CCJ judgment and reading Article 106.6 and 106.7 of the Constitution will come to the conclusion that after September the 18th, the constitutional life of this government comes to an end. So you have a government in place that will not enjoy constitutionality and legality. And that is a state of anarchy. The government will not be able to effectively govern. It will not be able to effectively do all the things that the state is required to do to protect the citizenry generally and specifically businesses. That is as clear, and I have also detailed in my presentation the caretaker status and the limitations attached to it. And that is the current position. And I also spoke of what will happen when that expires. And I referred to data being, studies being done by the private sector and the Georgetown Chamber of Commerce, in which it has recorded low decline in businesses as a result of the no confidence motion. The gentleman spoke about the climate in Berbice as after the no confidence motion. So I don't know how one can really sit in this audience and say that that issue has not been addressed.
Thank you very much, Anil.
I did agree that the nature of the business that the members of the private sector would treat with the government is largely of a commercial nature. And governments are bound by the decisions of previous governments. So any commercial transaction, you're still free to enter into commercial, routine commercial transactions with the government. You could still tender for certain contracts, etc. So those are routine matters. So there's nothing imperial entry into a commercial contract with the government in this, even in this state of an interim government.
Mr. Ramkarran wants to get a piece of that question. Go ahead, sir.
Mr. Chairman, ladies and gentlemen, it's no secret that Guyana is relying on the development of the oil industry to trigger economic development on a grand scale. The biggest investor at the current time is ExxonMobil, and other oil companies will come on stream later once discoveries are made. There's a lot of discourse about local content, and those who are involved in business are very much aware that many business people, small, medium, and large, are preparing to enter the supply industry for the oil industry on a wide scale. From my profession, I am aware of the number of people who are establishing companies and making inquiries. There are a vast number of people. And those investments have already started. Now, they have not impacted as yet on the economy, but they're going to impact very soon. Next year, we're going to get production. Now, do you seriously think that a major company like ExxonMobil or one of the others, or its partners, will seriously want to promote business or engage in business, and this is billions of US dollars we're talking about, in a country that has a government that is unconstitutional, that's not supposed to be in office, or that has legitimate questions as to its status and its stability. Don't you think that ExxonMobil will want to hold back? And if ExxonMobil holds back, don't you believe that that will do enormous damage and harm to our economy, not only in its growth, but in its international stature? Comrades, we are in great jeopardy if this government does not call elections by September 18th. Or talk to the opposition and get an extension of time. Guyana would be in great economic and political jeopardy and instability. Thank you.
Thank you. Can we have another question, sir? Yes. Go.
First, let me reiterate. The government has nothing to do with the conduct of elections in Guyana. The government cannot hold elections. GCOM holds elections. That's what the CCJ said. And so we are ready, willing, and able to have an election. We want a credible election, and the leader of the opposition ought to operate responsibly, meet with the president, get a 2/3 extension. If he doesn't get that, the president is ready to name an election date, provided he is advised by GCOM as to its readiness. This was actually the position of the former president of Ghana, Mr. Barjaglio, in 2006. I don't know where the law has changed. So the government is not unconstitutional. And again, we are beaten up on the judgment of the CCJ. The CCJ has said the cabinet and the president remain. What you want is, what is it you want? Do you think ExxonMobil would prefer that there's no government, so all those people could come over the border, all the persons who have been pushed back to come out back on research? Is that what you want? You have to have a government. And the government, according to the constitutional expert of Canada, retains the panoply of powers, but you are restricted. And we are clear about that. So it's pure propaganda to say that we are unconstitutional. It's flying in the face of the decision of the final court. And we, as I'm saying, we must stop inflaming the population with this type of fake news. It must stop. And I agree with the speaker with this doom and gloomers, because the investment that ExxonMobil has, the oil will continue to flow, irrespective of which government is in office. The important thing for the Guyanese people, though, is which government will be able to distribute the proceeds of the oil and gas and the benefits from the oil and gas. And I think the Guyanese people are very clear. They don't want the distributor they had for the last 23 years. Because they impoverished everybody from the quarantine right down. We're impoverished. It's just friends and cronies. So the Guyanese people clear about that. They want President David Arthur Granger to have custody of distributing the profits from the oil and gas. That's very clear.
Thank you very much. Could we have
We don't call elections.
gentlemen? Could we have two questions on the floor, then you go to answering? Go, sir. Thank you.
Yeah, no, thank you for the opportunity to ask a question.
Go ahead. Go ahead.
My name is Doug Mears, and I have my own small investment in Guyana, but I also was asked to provide some political risk analysis for investors looking at potential investment opportunities here. And I can certainly check the box on political rancor. But I'd like to go back and say that despite the political rancor, there's a national consensus, there's a consensus between the political parties on the way forward for Guyana to address all the pressing problems that are out there but haven't been dealt with over the last 20 years. And that's the appalling state of infrastructure. It's the lack of electricity. It's the continued disparity between the rich and the poor, and it's the bad roads and the killing traffic. And so my question to all of you is, can you put the rancor aside? Can you provide assurances to foreign investors that there's a national vision, there's a way forward, there are plans that both parties are committed to address these problems? Thank you.
Thank you very much. Can I have the other question and then we'll go to answering? I know you had a long question, so go ahead. He had his hand up before, sir. Go ahead.
My name is Sharir Chan, and the question is very simple. Just a yes or no answer. If the Guyana Elections Commission decides that elections can be held by September 18th, would you, Mr. Attorney General, so advise the President? Yes or no, please? Yes or no, sir? No, I'm starting with you, please, and then the
I think,
Thank you, sir.
I think the president is on record of saying that it is GCOM to determine the readiness of elections in Guyana, not the president, not the government. So once GCOM determines its readiness, we good to go.
So the answer is yes.
Yes, we're good to go. We have said that all the time. You know, we're good to go. We're very confident in these elections. We have done good work, and we will ask the people to allow us to finish the work.
Thank you. Anil, I want to get into that question, and there's a question from the gentleman earlier too. Please remember that.
The question from the gentleman. Sir, of course, infrastructure has to be fixed. The cost of energy has to be reduced. Internet access has to be increased. And I can list 100 more things to add to the list that you have provided us. But none of those things are possible unless the society has a rule of law, unless there is a lawful government in place that will ensure that those things are delivered. So that is why in my presentation I said that a legitimate government, constitutional rule, the rule of law are sine qua non to society itself, civilized society as we know it. And what I have been advocating or articulating is that we are at a crossroad. The rule of law is on trial here, and the government will lose its legitimacy on September the 18th. That is the issue. So yes, your issues are important, but this is the foundation upon which those issues have to rest. This foundation must be laid first.
Thank you very much, Anil.
I just want to say that political rancor in Guyana is not worse than it is anywhere else. In the United States or Great Britain that have big issues at the moment, I don't think our political rancor is worse than those countries or many others. But the political rancor in Guyana will reduce, and you will see a greater unity among politicians. If the political rancor in Guyana has an ethnic dimension, because we have two large parties that draw their support from our two large ethnic groups. So it has that inevitable ethnic dimension. But this will be reduced when the ethnic dimension is removed from our politics by devising a constitutional system that ensures that the main political parties work together in the same executive. That has been called for by both of the major political parties for a very long time. by the PVP since the 1970s, and by the PNC APNU since 2001. And neither has implemented it, because when they get into power, they see that if they implement the proposals they have on the table, they will have to share that power. We, the people, have to force them to honor their promises.
Thank you very much. Ladies and gentlemen, I just want to remind you guys that I have a lot of questions from those who are viewing us online. So I think the former president asked for a question, and there's a gentleman there. And after that, we'll go into some of the online questions that we've been receiving, pertinent ones. Go ahead, sir.
Just wanted to clarify something, because I heard the Attorney General repeating over and over that it is not the president who should call elections, but GCOM. Now, that had been so before continuous registration. I thought Ralph, who headed the Constitutional Reform Commission and had Hassan Paris as his secretary, that they would have clarified that position. Before, when you had, before every election, you had to go and do another kind of registration, that was the case. And it was precisely because of that kind of inconvenience that it was decided that we will go to continuous registration, so that we will be like a normal democratic country that can call an election within a month. That was the purpose of continuous registration, so that to give not GCOM to decide when elections should be held, but the president, the executive, to decide when elections should be held in our country. I want to clarify that one point. The second point I want to clarify is this talk, the Attorney General again said, I prorogued Parliament for more than a year. That is totally untrue and a deliberate distortion. The prorogation of Parliament that I did was for 3 months, and I called elections. 3 months. Moreover, I acted within the Constitution as it was constitutional. And I can point to you, like you talk about a democratic state like Canada, where Prime Minister Harper prorogued the Parliament 4 times. One of the time was to avoid a no confidence motion. But that is not being spoken about. What is spoken about my proroguing the Parliament? But I went to the people after the purpose for proroguing the Parliament did not work. I went for a mandate for the people. Why don't they, your government, go for a mandate after you have no confidence motion? Thirdly, they talk about the growth of the economy. You can have growth without development. In fact, one of the PNC former economic minister had said so, that in the Burnham period, we had growth without development at one stage. And you can look at other countries too. Angola, which produces oil and produced diamonds, had big economic growth, but they had the poorest people in the world and a civil war at the same time. So looking at only figures, it's not enough, because with the advent of oil, there will be a big distortion of how economic figures are viewed. I just want to make those clarifications.
Former President, thank you very much for your commentary, but normally we would do a question and answer. I didn't get a question from you, so
yeah, but just
I know you clarified.
Just to say that the former president did describe the situation in the last 22 years, because all the indices showed that we were among the poorest. We had the largest unemployment in this hemisphere, and the quality of life, all this is there. So it's not nothing new to Ghana. That's why the people vote for transformation. And we had started infrastructure. It is difficult to roll back 23 years in 3 years. But we are on the way. We've touched most communities in this country who never had light, who never had water, who never had good roads, garbage disposal, all these things. They were neglected, marginalized communities in the last 22 years. They now having light, they now having water, they now having roads. But how much could you do in 3.5 years? You got to patch one road, you fix one road, and the rest, so we're hoping, and in fact, the no confidence motion that has come as a distraction. So it's really only 3.5 years we had on this transformative path. And we have shown clearly the direction we're going. The infrastructure development of this nation, of this country, and the education of the people of this country, and also looking at health and the other issues that are affecting the Guyanese people. We have already embarked. We haven't got there yet, but we are on the way, Mr. Chairman.
Thank you very much. Gentlemen, ladies and gentlemen, please try to be civil. Please not heckle the speakers when you're speaking. But as we're on this point, there's a question online that relates to what everybody just said. This comes from Chan Prasad. You're going to go, Justin, sir. But Chan Prasad said, and this is for all three panelists, what will you do for healthcare? What will you do for education? What will you do for old people's pension? When will you fix blackout problem in Guyana? And that goes for all three people who represent different political parties on the stage. See if you can go and answer that in any shape and form that you please. Anyone want to go first on that? This was an online question from Facebook, from the viewers, one by the name of Chan Prasad. That was one of the questions. Anyone wants to go at that, or you want to pass that? Thank you. Let's move on, sir. You will answer it? Okay.
Yes, because we have done that. We have increased old age pension by nearly 100% since we came into office. We have done a lot in terms of the minimum wage. We have had increases well over 80% for the workers. So we have embarked, as I said, we as a government, we have embarked on these things, on these challenges. And let me say this. The workers that were displaced on the sugar estates, that was something we inherited. We never created that. When we came into office, it was $90 billion in debt, guys ago. And the president has undertaken to reestablish the estates that could be reestablished, and to deal aggressively with this whole problem of finding whether employment in the industry or alternative employment for the workers. So these are that's what I'm saying, these are problems we inherited. A brand new government, and you confronted all these things. Rice, you had to get $30 million to put into rice almost immediately. So, and we inherited big judgments that cripple our fiscal space. And we have been grappling with these things, and we have shown you the progress that we have made in 3.5 years. And we will continue on that path once the people of Guyana give us the opportunity to sow them.
Can we have a question, sir?
Good afternoon. As a young person, I have grown. My name is Agri Marsh. As a young person, I've grown up in years before this administration. I've been here while this administration is in power. I am fundamentally focused on development for two reasons. One, to raise a family that can access all parts of state without fear of any kind of intimidation, regardless of who's in power. So I am asking, like the gentleman asked earlier, for not to get rid of the rancor, because I know people will be people, but let's focus some more time and energy, I think the lady referred to it earlier, on development, on coming to a compromise, because Guyana's development will benefit all members of all political parties. What can we do as a right-thinking, intelligent country to come together, agree on a way forward that our generations and ones coming afterwards would have a good future? So my question is, I'll repeat it. What can we do as intelligent people in this room who that have different level of interests to come together with intelligent backing and says, okay, we're going to agree on this to move country first, Guyana forward, not our political interests or business interests, but Guyana forward. That is what I want to hear from persons who have been in parliament for long years as a young person, because I am not one of those who will hold on to a particular view. I am about Guyana moving forward and building it for a better generation. How can we collaborate to move Guyana forward as an entity. Thank you.
Thank you. Mr. Ramkarran will go ahead.
I won't share those views. I will challenge my partner. I will challenge my good and long-standing friend Basil Williams to persuade his government to implement the proposals made at the elections in 2015, where they promised the people of Guyana that they will reform the constitutional system by having separate presidential elections, and the person who wins, of course, will become the president. But the person who gets the second highest number of votes will become the prime minister, and every political party that gets more than 30% of the votes will have a share in the government. I want to ask Basil if his government will implement that promise before the next elections, and that is my system.
Briefly, with the risk of being repetitive, Ralph, you are running far ahead of the game when you are referring to constitutional reform, when we cannot have constitutional compliance. We can't even obey what we have, despite the fact that it's written in clear language, interpreted for us. And yet we have a difficulty and you want to change. We have this system for how many years? And we can't seem to understand what this system says. You want to implement a new one?
Thank you, AG.
I know why Anil accepted, because he knows that we started out the new government and in the parliament, we started out to get to involve the parties. We actually passed legislation. We took legislation for constitutional reform to the parliament. It went into committee, and that's where it got bogged down. We can't seem to get Anil and Priya and the others to come to these committee meetings and talk constitutional reform. We can't get them to come, and they are not interested in constitutional reform. They're not interested in diluting the powers of the president because they were intoxicated with those powers for 23 years. But we seriously want to have reform dealt with. Once we could get them to come and get a quorum, it's like the election commission. You come in here and you're talking about no elections being held, but the opposition appointed commissioners had not been attending meetings. So you can't have a quorum. GCOM couldn't get a quorum from since January to hold meetings until this new commissioner has been appointed. They were not attending meetings, so no work could really be done by GCOM. And then they come around the corner to blame the government. We have nothing to do with that. All our commissioners that were appointed by the government, they attend all the meetings. So the issue is the opposition is not serious about constitutional reform. But the people have shown them that they are prepared in 2 elections to move away from that old paradigm of seeking to have some racial vote. The Guyanese people are not interested in that. They've shown you that. And if you're going to feel that you could go on that platform, you're going to be sorely disappointed because they never benefited from it. They never benefited. And we have to move on as a people and as a country. We're ready for constitutional reform. Once the PPP decide that they want to play ball with us, we're ready.
Thank you. I have a question from online here. and this is for all three of the panelists. As a caretaker government, how does this affect government's ability to enter into new loan agreements with multilateral partners and bilateral partners? Also, what does it mean for private sector entities that want to enter into contracts with the government? Maybe we can start with AG as you have the mic in your hand.
Yeah, but I thought I'd answer that from the outset, that private sector could enter once there are commercial contracts. When the government, of course, when the government enters into the marketplace, they can't invoke state immunity and all that. So it's easy. If a government runs up a debt, the debt has to be honored. So there's no difficulty with the private sector entering into contracts. But in terms of, as I said, the agreements with IFIs and the like, enter into a mileford like contracts and so that's not, we're not going to do those things. We're not going to make state visits and all those things. We have acknowledged that we want elections in the shortest possible time. We keep saying that all the time because we are confident that the Guyanese people will return us to office. And people are stymieing the work of GCOM by holding their commissioners back from attending meetings. That's the point we're making. So no decisions going to be made since January. So let's see if they're going to attend meetings now that we have a new chamber.
Anil, do you want me to repeat the question, sir?
The thrust of that person's question was to examine the economic and commercial consequences of the government's current status, limited status. One thing Basil Williams has conceded is that they can only enter into routine contracts. Routine contracts cannot invigorate the economy in the manner in which we would like to see it. It cannot bring the transformational changes. Routine contracts are just routine contracts. It's just to keep you going. What the thrust of that question is to emphasize that you cannot enter into the contracts that matter. The contract that matters are the contract that will have financing done or of the magnitude that will come from multilateral institutions. That we cannot do. So for how long are we going to continue this routine thing? Mr. Williams in his presentation said that even if you extend Parliament, you don't have to extend it for 3 months. So he has an idea that you can extend Parliament forever. You understand what we are dealing with here? The level of misunderstanding is gigantic here.
Mr. Ramkarran, you want to? Good, thank you. I have another question online from just now, Wesley. Let me just give this other question and Wesley Carton is going to go. This question really goes to the gist of what all three of you spoke about earlier, and is from Chris Singh. What is the possibility and certainty of general elections being held by September 18th? Maybe you have the mic in hand, maybe you can go first and you can pass it either way you wish.
Possibility and probability are two different concepts.
Not possibility and certainty.
Of course it's possible. It's possible tomorrow the president can issue the proclamation fixing a date for elections. Lowenfield has already indicated that with one cycle of claims and objection, the list can be ready. And of course we can have elections. So it's quite possible, but it's not probable, having regard to the position of the government representative here. That's the problem. You know, let me make this point. In India, in Malaysia, in countries that were considered third world quite recently, and are on par with Guyana, Singapore, etc., they gained independence around the same time. Those countries are now sending people to the moon. They are developing new technology for cell phones. They're building new computers. They're improving their educational system to such a way to provide North America with the scientists that they need. We in Guyana still can't understand our constitution. We don't understand what OR means. Remember how for 1 year, Article 161(2), when that was being interpreted, when we had to go through that ordeal, where it says that the president shall appoint a judge, a former judge, a person qualified to be judge, or any other fit and proper person. That or was interpreted, that provision was interpreted as only requiring judges. Remember that? So we didn't understand or, the disjunctive or. That took us 1 year. We had to go to the Privy Council, to the CCJ, to resolve that. We are reading our own court judgment, and we can't make sense of it. That is the state of backwardness that we are in, while other countries, similarly circumstanced, are doing the things that I have alluded to. So far we are from the civilized world, and we are going backward every day.
Thank you.
We are battling over here whether elections should be held. Elections are fixed by law in certain countries.
Thank you. Mr. Williams?
Well, my learned friend hasn't answered the question.
You want me to repeat the question?
No,
Is
I'm
it-
saying,
okay.
I know the question, but
Okay.
he hasn't answered the question. Our position is GCOM has to determine the readiness for election. But for GCOM to do that, the opposition members of GCOM must go to meetings, they must go to the meetings and make decisions to enable GCOM to discharge its mandate and its remit. You know, it's incredible that people could see a decision from the CCJ and they have so many problems interpreting it and attributing all kinds of interpretation to the clear language of the CCJ. Could we have election order before the 18th of September? No. Could we have the cabinet and president resign? No. Could we have elections within 3 months from the 18th of June? No. Could we have the list of 30th of April as the base list of elections? No. And yet we have Mr. Nandalall coming to say something entirely different. So I'm wondering if Mr. Nandalall, in fact, Mr. Nandalall never really took part in the arguments before the CCJ. Maybe that's why he feels that he could come and disrespect the decision of the CCJ. But this is not a laughing matter. I'm happy I'm streaming live because as a lawyer, you have a duty and responsibility to discharge. You have taken a note as a lawyer. And you cannot continue to spread disinformation to the Guyanese people. The judgment of the CCJ is clear. You ask for certain orders and they will refuse. You've come back to the first instance court to relitigate the same things you asked for. You want the court to compel a date to be issued and fixed. And all these things have been dealt with at the highest court. And you have to remember the oath that you took as a lawyer.
Thank you. Mr. Ramkarran, do you want to answer any part of this question? Could you pass the mic, AJ? Thank you. Mr. Ramkarran, do you want me to repeat the question?
I didn't take an oath, but I'm worried about this continued allegation or assertion that the CCJ refused orders. The CCJ didn't refuse orders that Christopher Ram, the leader of the opposition, and the other people applied for. The CCJ declined to make them. There's a very big difference. The CCJ did not refuse the orders. There's nothing in the decision about refusing orders. The CCJ made no reference to the application of the claimants for the orders that is being talked about. They made no reference whatsoever. They did not reject them. They just declined to grant them, and they went their own way. They went their own merry way and granted what they just said that the 106 applies. That's all they did.
Thank you. So, ladies and gentlemen, we have 2 more questions from the floor, and then we'll give each panelist 3 minutes closing remarks, right? First one is from Mr. Wesley Corton. Go ahead, sir.
Thank you, Mr. Chairman. My question is a simple one. Should the new chairman of the Elections Commission next week indicate that elections could be held anytime as of November 30th? Are the political actors prepared to work towards having an election soon after a date that is indicated by the chairman of the Elections Commission?
Thank you. Anil, you want to go with that first?
Well, the earliest date possible we are asking, we have interpreted the court rule, the court to have ruled that September the 18th is the date. Any date closest to that, I suppose, we will accept.
Thank you. AG?
Well, I'm not going to arrogate to myself an interpretation of a clear judgment of the highest court of this land. There is nothing about the 18th of September issued by the CCJ. In fact, the CCJ said we will not, for example, fix a date. Now give deadlines. So they answered clearly those things. And I'm saying, and I'm reiterating the government's position, that once GCOM issued signals its readiness for elections, we are good to go. That is our position.
Thank you. Mr. Ramkarran?
Thank you very much, Mr. Chairman. I belong to the newest, fastest growing, most popular political party, and we are ready at any time.
Thank you, sir. Kit Nascimento, can I get your question, sir? That will be the last question for the afternoon, and then we'll go to the 3 minutes each closing remarks.
First of all, I'd like to thank Amcham for bringing us to this very exciting event. We've heard all of the viewpoints of the parties about to contest an election, those who have been in office and are out of office, and those who are currently in office and may be out of office. What we haven't really heard is what this is doing to the economy. Because it's going on for a year now, since we've had a no confidence motion. So I ask you this, Basil. Don't you agree that as long as your government remains as a caretaker government with restricted executive authority and powers, the country remains in a state where it cannot proceed effectively with development? I ask you that. And I haven't finished. I ask you this too, merely out of curiosity. How do you make a distinction in the context of a no confidence motion between the person involved in exercising their conscience as distinction from exercising an act of treachery? How do you make that distinction? Because in a no confidence motion, somebody, if that motion passes, or some bodies have crossed the floor. You describe it as an act of treachery. But how do you make that distinction between whether it's an act of treachery or an act of good conscience? Thank you.
Thank you, Kit.
The questions apparently have been directed to me. I should deal with the latter one first, of course. I think you just came in, Kit. but I did address the distinction. What was treachery? And yeah, but I did address it, the question of why I said it was treachery. Okay, and I will move on. Now, the issue of being in the interim government is not one of our making. It's not one of our making. We have been saying repeatedly, we are ready to participate in elections as soon as GCOM is ready to hold elections. And since you've been around, and you were part and parcel of elections that saw a lot of bloodshed in this country, a lot of violence, I'm surprised that you're coming to ask me a question like that. When you know the importance of having a credible elections in this country, when you know the importance of having a credible list, you were right up front and center in those arrangements. When you have elections, the tensions are exacerbated. You even had neighbors had to come in post-1997 to settle these things. So I don't know at the level of development that we have. We didn't make any money in 23 years. Those who made the money know who made the money. They are willing to go to an election with an anyhow list. They are ready for their properties and all these things to be subjected to those same post-election type of violence that we had in the past. Isn't it? What is important here? You asked me what's treachery? That act of Mr. Sipasad Charandas Prasad has motivated the base in this country that might have been difficult for us to have done in a short space of time. Everybody's energized, everybody's up front, ready. The last thing you could do is give them a list, and when they turn up to vote, the name not on the list, they got to go to Escribo to vote, and all those things. Is that what you want in this country? You operating as though people are strangers here, and some people just come to the country, you could tell them anything. We always have to have at the back of our heads how fragile our elections are. And for the last two elections, because of moving towards inclusiveness, and breaking it back of racial plebiscite, you had no violence. In 2011, in 2015, even in 2006. So we have to ensure we have a credible list. We owe it to the Guyanese people. Because there's a lot at stake at elections. And people who had voted to put in the APNU, AFC in government, you think they are happy about the act of treachery that has truncated the 5 years they vote for transformation? So I don't know why we bury our heads in the sand. Guyana at this time needs a credible election. You could only get that with a credible list. GCOM has a policy of updating its list, creating a new register every 10 years. The last time they did it was in 2008. In 2018, they issued an order for another house to compile it. The Constitution said they could compile. It's a new register. Who in the country would be resident in a registration division in which they live? If you're not in a registration division in which you live, you're not on the list. So that would show you how many people out of the country, how many people have died, and all these things. So to me, it's hypocritical to come and just pose the question when you know the deep-seated issues that attend national elections and general elections in Ghana. And I don't want to say, well, yeah, go, okay, hold the election, because the consequences will be there. Everybody knows this. So let's get the major players, get those constitutional actors. That in fact should be the call by these bodies in this country. Get the constitutional actors as envisaged by the CCJ, bring them, encourage them to get together and make decisions in the interest of this nation. Not come with half-baked partisan proposals that you know would generate a lot of animosity and hostility. You know that. So please, do the Guyanese people a favor and put up a proper proposal. Ask the players, come together, let's get a 2/3 extension, let's get a date, and let's run the elections.
Thank you. Anil, you want to get into that question there?
Summarize all that has been said.
Okay.
It's our way or it's destruction. That is all that amounts to. You don't have nothing to do with law and order and constitution.
Guys, could we just be civil? Mr. Former Speaker, do you want to? Thank you very much. So, ladies and gentlemen, well, guys, I know in the beginning I said 7 minutes. We took different minutes, but on the closing, I'm just asking you guys if you can maintain the 3 minutes. I know your closing remarks is between the participants here and their homes. But before you give your closing remarks, I would just like to say to you that the online viewing was 1,000 strong consistently throughout the discourse this afternoon. That means that the Guyanese people and those around the world have an interest in what goes on here. So whatever you said and so on went global, not just in Guyana alone. We have people watching from all over the world. Thank you very much. So Mr. Ramkarran, you have the mic. Maybe you can start with your closing remarks, sir.
Thank you, Mr. Chairman. Thank you for inviting me, and I think I speak on behalf of my two colleagues to inviting us to share the platform and to address issues of concern. I'd like to thank the audience, so many of you for turning out and for listening so quietly and attentively. I don't know whether we were talking nonsense or otherwise, but thank you anyway. I just want to say that in a normal country, when no confidence motion is passed, it is expected that elections will be held. The fact that we are battling over whether elections should be held or not and when indicates that Guyana is not really a normal country. And why it's not normal is because we have two large ethnic blocs who are very suspicious of each other and who feel that when one ethnic bloc is in power, the other ethnic bloc is has just lost everything. And this is not unusual. I'm not an expert, but this is not unusual in countries that are divided by race, by ethnicity, by religion, and such things. Other countries have gone to blows, have gone to war, people have died. Fortunately, we had our skirmishes in the 60s, a little bit more than skirmishes, but we have maintained the peace so far, substantially. I think what has happened here over this no confidence motion will continue. You'll have something else next year and something else the following year, and it will go on endlessly until our political problems are resolved. I don't want to sound like a broken record, but we have to find a way in which we can overcome this ethnic domination in our politics. And it's not, appeals to the good nature of people is not going to work. Most people want this to end. But most people also have their ethnic loyalties, and it's very difficult in situations like this to release that ethnic loyalty, even though you know it's the right thing to do. So we need to draw up a political system that minimizes it as much as possible, and minimizes it in such a way that the political representatives of our people are able to work together. That is what the message I have, what I want to say, and what I want to urge you to consider.
Thank you,
very
sir.
much.
At least you stick to the 3 minutes.